beyond and to the exclusion of every reasonable doubt. And 2, the act was imminently dangerous to another in demonstrating a depraved mind without regard for human life. That element has not been proven beyond and to the exclusion of every reasonable doubt. The judge told you about attempted manslaughter by act. And the judge told you that the element that has to be proven is that Ray Greenlaw intentionally committed an act which would have resulted in the death of Justin Riley, except that someone prevented Ray Greenlaw from killing Justin Riley, or he failed to do so. But further, the judge told you, in regards to attempted manslaughter by act, that in order to convict of attempted murder, manslaughter by act, it is not necessary for the state to prove that Ray Greenlaw had an intent to cause death, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide. And the reason why the state has not proven Ray Greenlaw guilty beyond and to the exclusion of every reasonable doubt of attempted manslaughter by act is because he was justified in the use of deadly force in defending himself on that front porch or in that front yard against Justin Riley. The judge also talked to you about another lesser included offense of aggravated battery. She told you the elements of aggravated battery. There's 2 elements that she read to you and that you'll have the opportunity to review when you go back into the jury room with the jury instructions. Those elements have not been proven beyond and to the exclusion of every reasonable doubt. The defense, as mentioned, it's been clear from the very beginning, to the attempted murder charge that's pending against Ray Greenlaw against Justin Riley is justifiable use of deadly force. And the judge has already told you that the use of deadly force is justifiable only if the defendant reasonably believes that the force is necessary to prevent imminent death or great bodily harm to himself while resisting another's attempt to murder him, or any attempt to commit aggravated battery upon him, or any attempt to commit burglary of a dwelling upon or in any dwelling or residence occupied by him. The judge further told you that a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of attempted murder, aggravated battery, or attempted burglary of a dwelling as defined above against himself or another. Mr. Lawrence talked about the issue of self-defense when it came to the murder charge. But the judge has told, we have 2 separate issues of self-defense with Ray Greenlaw. The self-defense against Justin Riley and the self-defense against Brian Leverett. The judge told you that if Ray Greenlaw was not engaged in an unlawful activity, there's no evidence that he was engaged in an unlawful activity. He was at his brother's house. He had the right to be there. But it says if Ray Greenlaw was engaged in an unlawful activity and was attacked in any place where he had a right to be, he had the right to be at his brother's house. He had the right to be on the front porch of his brother's house. He had the right to be in the front yard of his brother's house. He had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed it was necessary to do so to prevent death or great bodily harm to himself or another, to prevent the commission of attempted murder, aggravated battery, or attempted burglary of a dwelling. In addition, the judge told you, when instructing you on the law, that if Ray Greenlaw was where he had a right to be, which he was, he is presumed to have had a reasonable fear of imminent death or great bodily harm to himself or another if Justin Riley had unlawfully and forcibly entered or was in the process of unlawfully and forcefully entering a dwelling or residence, and Ray Greenlaw had reason to believe that had occurred. Ray Greenlaw had no duty to retreat under such circumstances. So according to the law that you've been instructed on, since Ray Greenlaw was not committing an unlawful act, since Ray Greenlaw was where he had a right to be, it is presumed that his fear was reasonable if Justin Riley was attempting to enter the residence at 9 Aspen Street. And the evidence establishes that that's what was happening. That Justin Riley was attempting to enter the residence at 9 Aspen Street. So it's presumed under the law that Mr. Ray Greenlaw's fear was reasonable. The judge also told you, when she instructed you on the law, that if in your consideration of the issue of self-defense you have a reasonable doubt on the question of whether Ray Greenlaw was justified in the use of deadly force, you should find Ray Greenlaw not guilty. That's exactly what we have here. There is a reasonable doubt on the question of whether Ray Greenlaw was justified in the use of deadly force. And under the law, you should find him not guilty of the attempted first-degree murder. And you should find him not guilty of any of the lesser included offenses that the judge instructed you on. Now, Mr. Will has made an issue of the failure of Ray Greenlaw to call 911 when he went back into the house, got the machete, and then came back outside. I think Mr. Lawrence mentioned this in his closing argument, but Ray Greenlaw had no obligation to call 911. You didn't hear anything in the jury instructions that the judges instructed you on that said that Ray Greenlaw had an obligation to call 911. Additionally, there's nothing in the law that says that Ray Greenlaw had to stay in the house. It was a house that he was living at. He had the right to go back out on that front porch. And why did he go back out on the front porch? Because he thought by waving the machete, anybody with some common sense would just leave, since he couldn't get him to leave previously. And that's when he was attacked by Justin Riley. That is when he used the force. That is when he used the force that was justified. Justifiable use of deadly force. Additionally, in regards to the issue of 911, based on the 911 tape of Nicole Robinson, along with the testimony of Deputy Heaton, it appears that the call was created at 5:36 in the morning, and units didn't arrive until 5:47, almost 11 minutes later. If you recall listening to the 911 tape, Nicole Robinson is like begging the 911 operator to get the units there, and they're going, oh, they're on the way, we had a shift change, they're out on 95 and International Speedway. So the reality of it was, it really wouldn't have helped Ray Greenlaw to call 911. It took them over 11 minutes to get to the scene when Nicole Robinson was on the phone to the 911 operator. So again, the state has failed to prove beyond and to the exclusion of every reasonable doubt that Ray Greenlaw is guilty of attempted first-degree murder. They have failed to prove beyond and to the exclusion of every reasonable doubt that he's guilty of any of the lesser included offenses. And why is that? It's because Ray Greenlaw was justified in the use of deadly force against Justin Riley. And therefore, the only correct verdict based on the law that you've heard and the evidence that you've heard is a verdict of not guilty as to attempted first-degree murder and any of the lesser included offenses. Now, the fifth part of this scenario of events is what happened at the time Brian Leverett was shot. Mr. Lawrence talked about what Wayne Greenlaw told law enforcement, that he heard something about a gun. Somebody said they had a gun. He thought they had a gun. He thought that if they didn't have one, they would go get one. That he felt threatened. That he thought he saw a gun. That a person indicated they had a gun. That he thought that he had been shot at. His thought process when he was firing the gun, or his Mini 14, was to protect himself. He was afraid he would get shot. That he was afraid for the safety of his mother, and that he was afraid for the safety of his brother. And that when he walked up into the carport and saw Brian Leverett laying there in the carport, he backed off because he wasn't trying to kill him, he was trying to protect himself. And so what did Ray Greenlaw say to police when he was asked about what happened relating to the shooting of Brian Leverett? He said when he and his brother came out of the house, they were still there. They ran off. He believed that they would return with weapons to retaliate, that he was scared to death, that he was afraid for his brother's life. He wanted to protect him. He was afraid for his mother's life. He indicated that he yelled freeze, or both he and his brother yelled freeze. Brian Leverett didn't stop. He was asked, if Brian Leverett had stopped, what would you have done? He said, I would have never fired if he had just stopped when we yelled out freeze. He said he was in fear for his life. He was in fear for his safety. When he was shooting his gun, he was firing, thinking self-defense. He wasn't firing in anger, but he was firing in self-defense. He was acting out of fear. And there was some comment, I think was talked about during Boy Dyer, about after something like this happened, why would somebody not call 911? He told the police he didn't call 911 because he knew a neighbor would call 911. So how do we know this is what happened back on October 29, 2011? We know from Nicole Robinson's 911 call. We know from the testimony of Mary Ann Fitzgerald, who lived at 13 Aspen and saw Brian Leverett go into his house. Mary Ann Fitzgerald was staying at 13 Azalea. She saw Brian Leverett go into 14 Azalea and come out with a shotgun and a flashlight on, walking down the street towards 13 Aspen. We know that she indicated he sounded intoxicated. We know from the testimony of the medical examiner that he had a 0.194 blood alcohol level. And I submit to you the fact that he had a 0.194% blood alcohol evidence is evidence tending to prove that Ray Greenlaw acted in self-defense against a drunken, inebriated aggressor. That the drunkenness of Brian Leverett led to his aggressiveness. So we know what Ray Greenlaw says, we know what Wayne Greenlaw says is true based on the testimony of Mary Ann Fitzgerald. We know it's true based on the testimony of Daniel Meadow. It was like pulling teeth to get him to testify and to testify accurately, but Mr. Lawrence has gone over the testimony that Daniel Maddow gave. Brian Leverett said he was going to kill those motherfuckers. He goes walking down the street. He's got the gun up, the shotgun up with the mag light, using it as a spotlight, looking for his target. That he saw the flashlight following the barrel of the gun. That at some point in time, the gun and the flashlight fixated to a point, and that Brian Leverett ordered the person to put the effing gun down. There was an exchange of words. He doesn't know who fired first, but he saw Brian Leverett shoot that shotgun. We also know what happened based on the testimony of Kirk Madison. He saw Brian Leverett run into the house. He saw him come out with the shotgun. He saw him heading up in the direction of 13 Aspen Street. He saw Brian Leverett point the shotgun between two houses. He saw two people pointing guns at each other, and then he heard shots. So what Ray Greenlaw and Wayne Greenlaw told law enforcement is confirmed by the testimony of those witnesses. It's also confirmed by the testimony of Detective Ford, who on cross-examination indicated that based on his investigation, it was confirmed that Leverett had a shotgun, and it was confirmed that Leverett fired a shotgun. Now, like Mr. Lawrence said, there appears to be an issue of whether or not the shotgun was fired. Daniel Maddow says it was. We know that this shotgun had a plug, and that with a plug it would hold 1 round in the chamber and 2 in the magazine. But in this particular case, when they found the shotgun that was plugged, it only had 1 in the chamber and 1 in the magazine, which is evidence that it was fired. We have the testimony of Investigator DeWeese, who did the look down the barrel of the gun. Mr. Lawrence talked about that. I'm not going to get into that any further. But we have the testimony of Allison Murtha, the gunshot residue person. Basically testified for half an hour, 45 minutes. Her testimony really boiled down to, I can't say that the gun was fired, but I can't eliminate the possibility that it was. So that's not evidence that this gun was fired. We contend that the evidence establishes that Brian Leverett fired that shotgun. But even if you believe that he didn't, the evidence is undisputed that Brian Leverett pointed the shotgun at Wayne Greenlaw and made threats that he was going to kill those motherfuckers. Undisputed. We have the testimony of Dr. Gallagher. He talked about the 2 fatal shots being from the Mini 14. We have the testimony of defense witness Shirley Danilek that established that she was home the night of the incident. We have the testimony of Mary Cassell, established that she was kind of part of a timeline, setting up a timeline when this was all going on. And then, as Mr. Lawrence already mentioned, we have the testimony of Investigator Robert Ryan, who measured the different distances between 9 Aspen and 13 Aspen and 9 Aspen and 14 Aspen, where Brian Leverett lived. So based on all the testimony and evidence that's presented as it relates to the first-degree murder count and the shooting into a building count, what, if anything, has the state proven beyond and to the exclusion of every reasonable doubt? The judge instructed you on the elements of first-degree murder. There's three elements. All three must be proven beyond a reasonable doubt before you can find Ray Greenlaw guilty of first-degree murder. The first element is Brian Leverett is dead. That's been proven beyond a reasonable doubt. No doubt about that. 2, the death was caused by the criminal act of Wayne Greenlaw. That element has not been proven beyond and to the exclusion of every reasonable doubt, because there was not a criminal act of Ray Greenlaw. And 3, there was a premeditated killing of Brian Leverett. That element has not been proven beyond and to the exclusion of every reasonable doubt. So the state hasn't proven beyond a reasonable doubt that Ray Greenlaw is guilty of first-degree murder. The judge told you about lesser-included offense of second-degree murder. There's 3 elements of second-degree murder that have to be proven beyond a reasonable doubt. 1, Brian Leverett is dead. Again, that's been proven beyond a reasonable doubt. 2, the death was caused by the criminal act of Ray Greenlaw. That element hasn't been proven beyond and to the exclusion of every reasonable doubt. And 3, there was an unlawful killing of Brian Leverett by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. That element has not been proven beyond and to the exclusion of every reasonable doubt. So since 2 of the 3 elements have not been proven beyond a reasonable doubt, and the state has to prove all 3 individually beyond a reasonable doubt, the state's failed to prove Ray Greenlaw guilty of second-degree murder. And finally, the judge told you there's a lesser-included offense of manslaughter. The 2 elements are that Brian Leverett is dead, Wayne Greenlaw intentionally committed an act or acts that caused the death of Brian Leverett. But additionally, the judge told you that the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Based on the fact that this was a justifiable use of deadly force, that Ray Greenlaw was justified in the use of deadly force in defending himself against Brian Leverett, he's not guilty of manslaughter either. Again, the judge instructed you on justifiable use of deadly force by Ray Greenlaw as to count 1, Brian Leverett. Basically, the law that she read to you regarding the attempted murder count is the same as it is in regards to the count 1, the first-degree murder count. It's our position that the state has failed to prove Ray Greenlaw guilty beyond and to the exclusion of any reasonable doubt of first-degree murder, second-degree murder, or manslaughter. And why? Because the use of force that he used, the deadly force that he used, was justified under the circumstances. And then finally, there's count 3, the shooting into a building. Mr. Lawrence talked about those. There's certain elements that have to be proven beyond a reasonable doubt. The state failed to prove that the shooting into the building was done maliciously or wantonly. And because that element has not been proven beyond a reasonable doubt, then you must find Ray Greenlaw not guilty of that count. Now, the judge talked to you about reasonable doubt. She read to you the jury instruction regarding reasonable doubt. Now remember, a reasonable doubt can be created by the evidence, a reasonable doubt can be created by a conflict in the evidence, and a reasonable doubt can be created by a lack of evidence. And we would submit to you that the evidence in this case that has been presented creates a reasonable doubt as to all 3 of the counts of this particular indictment. A reasonable doubt, as the judge told you, is more than a possible doubt, it's more than a speculative doubt, it's more than an imaginary doubt. If you go back into that jury room and have an abiding conviction of guilt, then the Law says that the case has been proven beyond and to the exclusion of every reasonable doubt, and you must return verdicts of guilty. On the other hand, if you go back into that jury room and you do not have a binding conviction of guilt, or if you have one but it wavers and vacillates, so first you do and then you don't, the law says that the state has failed to prove their case beyond and to the exclusion of every reasonable doubt, and you must find Ray Greenlaw not guilty. In the United States of America, in the state of Florida, there has to be more than a suspicion of guilt. There has to be more than a possibility of guilt. There has to be more than a probability of guilt. That may be the way it works in another country, but in the United States, in the state of Florida, proof of guilt has to be beyond and to the exclusion of every reasonable doubt. So if you go back into that jury room and you're talking and you're deliberating and you go, you know, I suspect that Ray Greenlaw is guilty of first-degree murder, shooting into a building, and attempted first-degree murder. The state has not proven their case beyond and to the exclusion of every reasonable doubt. If you go back into that jury room and go, Ray Greenlaw is possibly guilty of first-degree murder, shooting into a building, and attempted first-degree murder, the state still has not proven their case beyond and to the exclusion of every reasonable doubt, and you must find Ray Greenlaw not guilty. As a matter of fact, if you go back into that jury room and go, you know, Ray Greenlaw is probably guilty of first-degree murder, attempted first-degree murder, and shooting into a building, the state still has not proven their case beyond and to the exclusion of every reasonable doubt. And you must return a verdict of not guilty. What could conceivably happen in this case is you could go back into the jury room and start deliberating and go, I don't know what to believe. For so many different stories about what happened. I don't know what to believe in this case. I have no idea what really happened out there on October 29, 2011. And if that's part of the discussion, and if that's what you think, then certainly the state has failed to prove their case beyond and to the exclusion of every reasonable doubt. And you must return a verdict of not guilty. It's our position that based on the law and the evidence that you've heard in this courtroom for the last 2 weeks, the state has failed to meet their burden of proof, that there was justifiable use of deadly force against Justin Riley, that there was justifiable use of deadly force against Brian Leverett, and that the only true and correct verdicts based on the law and the evidence are verdicts of not guilty as to count 1, not guilty as to count 2, and not guilty as to count 3. Thank you.
State may present its rebuttal argument.
Thanks, Judge. You know, there's a real fundamental problem with the defendant's argument in this case. The argument that they were permitted to use deadly force is somehow premised on only what occurred at number 13. And because they were presented with a shotgun or a flashlight in their eyes, that they were entitled to pull the trigger. Well, here in America, you can't pull the trigger just because there's a flashlight in your eyes. And if you're going to kill somebody, you better be pretty darn sure why you did. Neither of these guys had any idea why they killed Brian. You watched their videos. And the problem with the analysis that's conducted by both the attorneys that just finished talking to you is it neglects the period in time in which they actually become aggressors. Those two guys behind me, they become aggressors when they walk out the door with the guns. That's when the law asks, were they reasonable in what they did? When they pick up the gun and pursue somebody, when they go into the darkness, looking for their prey, stalking them. That's the point at which the analysis begins. Not all the way down the street at 13. When they started this, did they have that right? And if you go back around to the 4 questions that we talked about earlier, when they started this, was it reasonable? Was it necessary to prevent or to preserve their own lives? Would any other person do this? And did they have a reasonable fear of imminent death or great bodily harm? The answer to all of those questions is loudly and overwhelmingly no. The defendants become the aggressors and are not permitted to the use of deadly force the moment that they arm themselves and walk out into the neighborhood. I read you guys the instruction a little while ago. I found it in there, you can too. The moment that they arm themselves, they are not allowed to renew the conflict. They have to do everything that they can not to. And the 2 defense attorneys have stood up here talking about how they were coming back to the house, how Brian Lever and Justin Riley were coming back to number 9. They were coming back, they were coming back, they were coming back. I think Mr. Lawrence even said they walked 1,700 feet to get there. They walked 1,700 feet to get there. They walked 1,700 feet to end up at number 13. They weren't coming back to the house, or they would have been at the house. There was plenty of time. There was 7 minutes. 7 minutes to walk up the street. And Brian Leverett never went beyond number 13. He never went beyond number 13 because he was protecting his friend. Because he was making sure that his friend was going to get medical attention. Because he told several people up and down the street, call 911. You know, the strange thing about this entire scenario is that Brian Leverett is the only person who's permitted to act with deadly force. Because he had been attacked and his friends had been attacked with violent action, with a weapon. They were being pursued into the night. And he was standing his ground and defending a place where he had the right to be, at his friend's home, where his friend was getting medical attention. And Brian Leverett is the only person in the entire scenario that's allowed to use deadly force under the law. And any argument to the contrary in this courtroom doesn't have any merit. It doesn't hold water. When Ray Greenlaw and Wayne Greenlaw left the house, each and every time they left the house, whether it was with a machete, whether it was with a gun, they were the aggressors. They were in control, and they were the ones who were responsible for the injuries in this case. All of the swearing and yelling and foot stomping that you saw up here for the last 2 hours doesn't change it a bit. The analysis starts at the threshold of number 9 when they cross the door. All your lives you've been responsible citizens and responsible gun owners. Every single one of you. And you've probably never heard anything.
That would be sustained. So jury is instructed not to consider the last statement. Mr. Roll will move forward from that point.
All your lives you've lived in this community, and you've never heard anything like the scenario that you've heard in here. And if you listen to the 2 lawyers long enough, if you listen to them long enough, you probably think there's nothing wrong with what their clients did. If you listen long enough, you think it's probably okay to wander the streets and attack your neighbors because they made you mad. At least that was the argument that I heard. But that's not okay. It's against the law. Even their clients know it's against the law. And you don't have to look any further than their own words in the video that you saw last Thursday. Ladies and gentlemen, these 2 men behind me are guilty. They are guilty of each and every single charge. And you should come back with the highest verdict on each and every single blank on the verdict form. But you don't have to believe me. Believe what the defendants told you during their interviews. The defendant's words should echo in your ears as you enter the jury room to deliberate. There is nothing more powerful than when a defendant expresses his own feelings about his guilt in the case. During the interview, both men were asked. They were asked, why didn't they just stay inside and call the police? Over and over, they said that they were sorry for what they had done. Ray Greenlaw said that he made bad decisions and that he should have stayed inside the house. Wayne Greenlaw agreed that he should have stayed inside the house and he should have called the police, and that under the circumstances it would have been the best thing to do. His words, not mine. And Ray Greenlaw goes a step further. He says that in his interview, he was really sorry that he did this, and he'll even be sorrier when he has to go to court. Sorrier when he has to go to court. Ladies and gentlemen, these men are guilty. Please find them guilty.
All right, ladies and gentlemen, as we discussed, this will be your final break for the day. At this point, now that you've heard everything, you may be tempted to start talking about it. You cannot do so until all of you are in the jury room together. So if you do go downstairs, either into the courtyard, or the coffee shop, don't start talking about it yet. You've got to come back. You have to sit in that chair for just a few more minutes for me to give you the final instructions on how to organize and structure your deliberations. So we'll take a 20-minute break. We'll actually be back in 10 minutes until 3, and I'll instruct you at that time. Everyone may be seated. Follow up to a conversation we had, I believe it was last Thursday, regarding juror number 2's unemployment situation as a result of serving on this jury. I'd asked the attorneys to come up with some potential names. I want to put that list together during the deliberations. So if you could, at the break, or right after they go into deliberations, work on that so my assistant can type up that list. I want to make sure that she, as well as the record, is clear that that list is after all attorneys have an opportunity to have a say in it. It's not coming from one source or the other, whether it be any of the attorneys or the court. So I'll ask you guys maybe to get together and just look at those names and give them to me as soon as possible. We're in recess until 10 minutes until 3.